Welcome to the Capital Forum interview series. My name is Sally Hubbard, and I have here with me today Seth Bloom. Seth is the president and founder of Bloom Strategic Counsel, which is a Washington, D.C. firm specializing in public policy, government relations, and antitrust analysis. Previously, Seth served as the general counsel and principal advisor for antitrust and competition issues for the Antitrust Subcommittee of the Senate Judiciary Committee for nearly 14 years until January 2013. So Seth, let's start out talking about some of the developments that have been happening with Google. Last month, there was an FTC staff memo that the Wall Street Journal published showing that staff had recommended enforcement action against Google, but the FTC ultimately did not take that enforcement action. There's been a big political outcry questioning whether Google's influence in Washington affected that. What do you think are the implications for this?
I think the implications are serious, and combined with the European Commission's filing of a statement of objections against Google. But I think maybe we can take them one at a time. With respect to the FTC staff memo, the FTC found, contrary to what Google told us, when I say us, the Senate Antitrust Subcommittee back in 2011 when we held the first hearing about allegations that Google was behaving in an anti-competitive manner. So the FTC found, contrary to what Google had told us at that time, that Google was in fact preferencing its own search results with respect to commercial sites, degrading or putting down on the search result page commercial sites that competed with Google properties, and the effect of this was to degrade the results of the Google search engine and therefore harm consumers. That's a finding of the FTC staff report, of which we have half of it, every other page, but the pages that we have, that's what was found in there. That's quite a significant finding. The question for today is this conduct still ongoing? What's happened since January of 2013 when the FTC closed its investigation? Or since August of 2012 when the staff report was written? And is this kind of behavior still ongoing? Now, interestingly enough, the European Commission on April 15th said, in fact, this conduct is still ongoing, and founded the basis to file an antitrust complaint, what they call a statement of objections, alleging that Google had violated the European competition law. That's quite significant. And I think antitrust regulators in the United States will pay close attention to it, particularly the antitrust regulator that really hasn't looked at Google's behavior in a long time, which is the Justice Department. I wouldn't be surprised if they've been in discussions with the European Commission and have been following this very closely.
And so you said this was counter to what was told to you at the Senate Judiciary Committee. When were those hearings?
They were in September of 2011.
And what did Google say at those hearings?
Well, at the time, Google said, we don't engage in these behaviors. The only thing our algorithm does is rank on what consumers prefer, and the whole purpose of our rankings is to give consumers the best result. Well, that's quite contrary to the findings of the FTC staff a year later, and the findings of the European Commission in the last few weeks, quite contrary to that. And in fact, as I said, I think the most significant thing I found in the FTC staff report was that the result of Google's conduct was to degrade the quality of the Google search result. We heard at the hearing from Eric Schmidt and, in conversations with Google, everything they were doing was in the interest of consumers. Well, the FTC staff, and more recent in 2012, and more recently, the European Commission found to the contrary. I think that's very significant. I mean, the basic antitrust test here is there consumer injury? And that's probably one of the reasons that the FTC was reluctant to bring a case, of the difficulties of finding consumer injury. Well, the European Commission found a lot of consumer injury. And if consumers are going to get a degraded search result, if it's not going to be the best results, they're not, when we talk about commercial search, they're not going to get the best prices for the products they're looking for, or the site that has the most convenience to them, the greatest range of products. That's clearly a consumer injury. And that's what was found, both by the FTC staff in 2012 and more recently by the European Commission. So I think those are quite significant findings.
And what do you make of the outcry that, immediately there were articles kind of insinuating that it was Google's influence political influence that may have affected the FTC's decision not to bring in action.
Right. So I have no way of knowing,
Right.
what the impact of political influence. What I do know is the FTC commissioners, all of whom I respect, are hardworking, smart, and quite ethical people. I have the highest regard for them. And the Chairman Leibowitz, who I worked with in the past, I have the hardest regard for him personally. So to me, I really can't, I don't have really anything to say
Right.
about that. I don't think that was the motivating factor here. I don't know what happened, but I don't have any reason to believe that was. I think what happened, though, is disturbing to me. It seems to me that the FTC decided that they were unsure if they could prevail in court in this case. And for that reason, they decided they weren't going to bring it. And they got certain voluntary commitments, not everything the staff had talked about, but on certain things. And they felt, well, we know we can get that, so we're going to get that. To me, though, and the FTC staff, actually, in fairness to the commissioners, the FTC staff on one of the allegations on search bias said, it's a close call, but we don't recommend a case. And from the half of the report that I read, it seems to me, why did they come to that conclusion? It must have been, well, we don't know if we can win the case. So I think, this brings up sort of two philosophies of antitrust enforcement.
Mm-hmm.
You might have a philosophy where you should only bring cases
Right.
which you're certain to win. The obvious price-fixing case, and you have a bug in the room and they're fixing prices. You're going to win that case. Or the obvious merger to monopoly or close to monopoly, which you really feel confident about. Another philosophy might be that as an antitrust enforcement agency, your duty is to enforce the law, and if you think there's a violation and you have evidence and you have a good
Right.
faith belief to do it, you should enforce the law. And it's really up to the courts to decide whether or not you've made out a case. It's not your province. And I think, in my mind, they were sort of following the first approach rather than the second approach. I think the better approach is the second approach. The people charged with enforcing antitrust laws that have to do just that, enforce antitrust laws. And they should, let the chips fall where they may, do their duty under the law. And I think they were too constrained by the problem they saw in winning the case. There's a lot of difficult cases that in the past have been brought. If that philosophy had been followed by Joel Klein in 1998, I don't think he would have brought the Microsoft case. There was a lot of precedent at the
Right.
time that they wouldn't prevail. Well, they did prevail. And I think that case was a great victory for the interests of antitrust and consumers, the Justice Department's victory in that case. And so I just don't think there was the will to bring a case and to roll the dice and to take the chance in this circumstance.
That makes total sense to me. And one thing that I've thought a lot about recently is this idea that we will only bring a case if we can win it. If you thought about that in other contexts, if other enforcers had that view, they only brought a murder case, if they knew they could win it, you're talking about under enforcement.
I'll give you another example. If the plaintiffs in Brown versus Board, I guess that wasn't a
Right.
case brought by the government, but we don't think we can win this case because all the civil rights precedent has gone against us. So it's the responsibility of obviously they have to be cognizant of what their chances are, and it's got to go into an assessment, but their number one priority has to be to fix a violation of law as they see it, and as the evidence shows. But right, if your standard is you're not going to bring the difficult case, well, the law won't advance, and a lot of behavior that's contrary to law will never be addressed.
Right, very good point. So even as difficult as it is to figure out whether politics played a role or not, how do you see this playing out with the new kind of the role of the Antitrust Subcommittee as an oversight agency?
Right.
Not agency, but in its oversight role.
That's right. Well, I think this squarely falls in the role of the Antitrust Subcommittee and its oversight role. Right after the revelations, right after the Wall Street Journal inadvertently got the report, which the FTC mistakenly produced, but they got it, and the Antitrust Subcommittee learned of it. Senator Lee, the chairman, learned of it. He announced that he was going to hold an inquiry into what happened. I think that's entirely appropriate. Because the report was so much in variance with the conclusions of the FTC commissioners, I think the number one duty of the Antitrust Subcommittee in both the Senate and the House is to engage in oversight to see how the antitrust laws are being enforced. So I think Senator Lee and the Antitrust Subcommittee are right to look into this, and I hope they will, and I hope they'll engage in a serious inquiry. And the other thing is, I think because of the legacy of the Antitrust Subcommittee's work in 2011 and 2012 on this issue, under Senator Cole, who's now retired, I think it's sort of in the institutional prerogative of the Antitrust Subcommittee to also look at this and see, what's happened since then. In addition to the release of the report, the FTC promised when it closed the investigation of Google in January 2013, they said they would remain vigilant and continue to monitor Google to see if they were engaged in any anti-competitive practices. I think it's entirely appropriate for the Antitrust Subcommittee to say, now that it's been almost 2.5 years, what has the FTC been doing, and how have they been engaged in this monitoring process that they promised? Have they in fact been doing that?
And how much does the political party of the chairman play a role in what the Antitrust Subcommittee does?
Well, traditionally it really doesn't. I mean, there's been this great bipartisan consensus that from both Democrats and Republicans that the antitrust laws should be applied and enforced, and there should be a bipartisan support of it, so it doesn't become political football. And in my time on the subcommittee, when Senator Cole was the chairman, he worked very closely with his Republican ranking member. And actually, I go back to the time that Senator DeWine of Ohio was the chairman, who worked very closely with Senator Cole as the ranking member. And that's a tradition that's actually continued since Senator Cole left under Senator Klobuchar in the last Congress. She worked very closely with Senator Lee. And so far, this Congress, in 2015 so far, Senator Lee has maintained that tradition. I mean, I think it's important. And even though Senator Lee is a conservative Republican and Senator Klobuchar is a progressive Democrat, I mean, that's true, but they've made an effort to work together. So we'll see how things go. It would be my hope that they maintain this bipartisan, the effort here should be to look at the merits of what's going on with Google, what's the FTC been doing, and I think that's hopefully what will happen. I don't think the politics of the chairman, that it's a Republican chairman and a Democratic administration, really should matter. That would be my hope. That's been the tradition of antitrust oversight in the Congress. We'll have to see how that goes over the next several months.
So watch and see.
Yes.
So let's talk about some of the mergers that are currently pending before
Sure.
the agencies, and get your thoughts on where you think they're headed. One interesting deal that the FTC is currently looking at is the Staples Office
Right.
Depot merger.
Right.
They did clear the Office Depot Office Max merger, a couple, what was it, 2 years ago now?
About a year and a half, November of 2015.
So, how much are they going to kind of be boxed in by the decision that they made in that report,
Right.
or their memo clearing that deal?
Yeah.
Or do you think this is fundamentally different in some important ways?
That's an excellent question, and because if you read the decision in Office Max, Office Depot, it really gives a roadmap for approval of Staples Office Depot. They basically said, unlike 17 years ago when the Staples Office Depot merger was challenged by the FTC and the court enjoined it from happening, saying it violated antitrust law, they said now in 2013 at the time, you have competition from the internet, you have competition from other big box stores like Costco, Walmart, Best Buy, but particularly because of the internet, the combination of Office Depot and Office Max really didn't give them market power. Those same considerations apply here. And if you were to go, if you followed that, you could say, well, look, how can you distinguish Staples Office Depot, Office Max? The only way to distinguish it is that you have two physical stores at the time, even after Office Depot, Office Max. Now you'll have one national office superstore. But I think the really important thing here isn't that, but it's the fact that for business customers, large companies that buy a lot of office supplies on a contract basis and a national basis, where the internet is less significant, does this deal create competition problems? I think that's where the case is going to be decided. So not so much on the retail customer, but on that. And for that, it'll be very interesting to hear what customers say, what these large national customers say. I think that could almost be decisive. If there's a lot of opposition from customers, that would make it tough for the FTC to approve it. But if there's not, then I think we see a path to approval following the precedent of Office Depot, Office Max.
And one thing that's been interesting with some of these deals where you're looking at the customer complaints is that we're seeing some of these big customers that don't really complain until it gets to be a 2-to-1.
Interesting point.
Don't complain if it's a 3-to-2, obviously not a 4-to-3.
Right.
And, is that really where the standard is now, 2-to-1?
Well, I hope the standard's not 2-to-1 because obviously by the time it's 2-to-1, it's almost too late.
Right.
But I think you're making a very good point there. You know, I think companies generally don't like to get involved, don't like to sort of stick their necks out in antitrust issues and mergers. Maybe they think they're going to want to do one themselves. So I think you're right. That has a lot. What you say has a lot of truth. The only thing I'll say to the contrary that, you know, we don't often know who complains because
Right.
what's done before the FTC or the DOJ is confidential.
Right.
So, you know, in terms of public statements, that might be right, but whether people are complaining behind the scenes.
Right. I mean,
It's a different
because
story.
I do tend to speak to a lot of customers, I have found that they
Okay.
don't have as much concerns until it gets to 2 to
Right.
1 with the big companies. And I guess, you know, that's another question is some of these really big companies, really big buyers are so completely focused on very detailed price savings that they view mergers as potentially getting them those price savings. And they're singularly focused on price, not really on quality, choice, diversity. And, you know, is that what should be driving the agency's decision making on these deals?
Well, I mean, I think the agency should definitely be looking at all those factors in addition to price. The problem for an agency is they really can't, it's very difficult for them to bring a case unless they have complaining customers. I mean, they basically can't do it without complaining customers. That's what the antitrust laws are designed to protect. They're designed to protect the consumer or a customer if it's a business. And you need that. You know, you have to win a case. I guess this gets back to winning a case in court. But in this case, you have to win a case, and you just can't do it based on sort of expert opinion. You have to have people that are complaining. By the way, just so I'm not sort of contradicting myself, I mean, there are plenty of people that complain about Google's conduct, so that wasn't really a
Right.
problem. But you're talking about mergers in the abstract. Yeah, you have to have customers that are complaining. And if you don't have customers that are complaining, the court's not going to grant you an injunction to enjoin the merger. So I think those are the constraints that the FTC and the Justice Department operate under. But you're absolutely right. I mean, they should look at issues beyond price, and companies should be smart enough to recognize that these issues exist as well.
All right. Well, thank you so much for your time today, Seth.
Well, I really enjoyed it. Thank you.
It's been a real pleasure, and we hope we can do it again soon.
That's
sometime.
great. Thank you.